Hey everybody, this is Advocate Lucinda, your empowerment lawyer. An individual contacted me about a severance agreement that she signed, releasing her employer of any and all claims and agreeing not to sue, of course, as a result of the severance package. Now she feels like the process was not fair and that the employer took advantage of her during the severance talks. She did not consult with an attorney, and now she wants to know if she can still sue her employer or former employer. And that's what we're going to discuss today, the severance agreement and release of claims. We're going to look at 7 signals that when such an agreement may be unfair and void. And to help us discuss this issue, we are going to look at a case, Torrez versus Public Service Company of New York. And we're going to use the acronym PNM because that's what the case uses. And it is a 1990 10 circuit case. So let's get started. And here are the facts. On March 31st, 1986, PNM notified Torrez that his position was being impacted as part of a downsizing of the company's workforce. The notification letter also informed Torrez he had until April 30th, 1986 to select early retirement, voluntary separation, or involuntary separation after requesting and receiving an estimate of his retirement benefits under a voluntary separation on the last possible day. Torres chose the voluntary separation package to obtain the additional retirement benefits. At that time, he signed a release which provided I, David F. Torrez, hereby release and discharge PNM, its officers, supervisors, agents, employees, and all other persons or entities for any and all claims which I have or might have arising out of or related to my employment or resignation or termination from employment by or from PNM. I also acknowledge full settlement and satisfaction of such claims, and I further understand that the consideration given by PNM is not to be construed as any admission of liability by PNM or its officers, supervisors, agents, employees, or any other persons or entities being released. The terms of this release are contractual, and all other terms of this release are expressed in this document. I have read this release and fully understand it. Subsequently, Torres filed a racial, national origin employment discrimination lawsuit. PNM moved for summary judgment, asserting that Torres had knowingly and voluntarily waived his right to bring the action by signing the release at the time of his employment termination. The court granted summary judgment for PNM. The district court held that the language of the release was clear evidence of Torres's intent to waive the discrimination claims. Torres appealed. He argues he did not knowingly and voluntarily waive his right to bring this action by signing the release. He contends that his intent and understanding must be assessed at trial and should not have been decided by summary judgment. Additionally, he asserts that the totality of the circumstances supports a finding that there was no knowing and voluntary waiver. And the 10th Circuit agreed, opining that in considering whether a general release was knowing and voluntary, some circuits purport to apply ordinary contract principles and focused primarily on the clarity of language in the release. However, the court went on to say the majority of circuits explicitly look beyond the contract language and consider all relevant factors in assessing a plaintiff's knowledge and the voluntariness of the waiver. And the 10th Circuit included citations from the Second Circuit, Third Circuit, Fifth Circuit, Seventh Circuit, and Ninth Circuit. There may be other circuits that take this approach, but these are the circuits that the 10th Circuit cited in its findings. And these circuits take this approach because of their concern for fairness. The 10th Circuit state, especially in light of the strong policy concerns to eradicate discrimination in employment, a review of the totality of the circumstances, considerate of the particular individual who has executed the release, is also necessary. Of course, in addition to the language in the written instrument. So let's look at the 7 signals and the court's findings on each. Sign 1. Is the language in the release clear and specific? The appellate court stated that the language of the release, although clear and unambiguous, failed to mention specifically waiver of employment discrimination claims. Sign 2. The plaintiff's education and business experience. Should that be a factor? Apparently, yes. The court noted that Torrez had a high school education, and it opines that that placed him in the unenviable position of having to sign the release or lose his retirement benefits. Sign 3. Did the plaintiff have sufficient amount of time for deliberation about the release before signing it? The evidence shows Torrez, after requesting and receiving an estimate of his retirement benefits under a voluntary separation on the last possible day, chose the voluntary separation package to obtain the additional retirement benefits. And at that time, he signed a release. So the court found that he did not have sufficient time. Sign 4. Whether plaintiff knew or should have known his rights upon execution of the release. The court noted Torrez had stated that it did not occur to him when he signed the release that he might be waiving possible discrimination claims. The court went on that Torrez testified he believed he was releasing claims arising out of the voluntary termination and the benefits package he was accepting. The court concluded this is not an unreasonable conclusion for a high school educated employer unfamiliar with the law. Sign 5. Whether plaintiff was encouraged to seek or in fact receive benefit of counsel. The court found that Torrez neither consulted with an attorney nor received encouragement from defendant to do so before he signed the release. And when you read the case, and I encourage you to do so, you will find that the appellate court cited a number of cases supporting the approach that in these negotiations, these talks, that the plaintiff should be encouraged to consult with an attorney before signing the agreement. Sign 6. whether there was an opportunity for negotiation of the terms of the agreement. The court noted that Torrez did not have the opportunity to negotiate the terms of the release, which was a standard form. When Torrez chose the voluntary separation package, he was required to sign the release. Sign 7. Whether the consideration given in exchange for the waiver and accepted by the employee exceeds the benefits to which the employee was already entitled by contract or law. Typically, courts don't focus on whether consideration is perfectly equal between the parties, right? Except where there is coercion or duress or some unfairness in the negotiations. And here the appellate court opined that there was some duress in the form of unfair economic pressure. It noted that Torrez had to opt between a nearly certain layoff with no retirement benefits or obtaining the future retirement benefits available only if he signed the release. Torrez testified at his deposition that he signed the release in order to save his retirement benefits, even though he felt he had been unjustly terminated. And again, you want to read this case because the appellate court refers to Coventry. And this case addresses duress in the form of unfair economic pressure. So please read the case. So, to the individual who asked me the question, I hope this helped you to come to a decision on whether you're going to sue or not. And anyone else who finds themselves in this situation, I hope it helps you. I am Advocate Lucinda, your empowerment lawyer, and we will see you next time. Take care.